These are federal laws that have been sitting on the books for over 50 years, and most car owners, shop owners, and parts sellers have never actually read them. They carry fines of up to $45,000 per violation. We are talking about the Clean Air Act anti-tampering provision, and right now, the EPA is using it to target everyone from eBay to reality TV stars to the guy in your town selling diesel tuners out of his garage. Let me break down exactly how this works, who is getting caught, and what it means if you are running a business anywhere near the automotive aftermarket. The law driving all of this is Section 203, subsection A, paragraph 3 of the Clean Air Act. It became law on December 31, 1970, the same month the EPA itself was created. In plain language, it says this: it is illegal for any person to manufacture, sell, offer to sell, or install any part or component where the main effect is to bypass, defeat, or render useless any emissions control device or design element installed on a motor vehicle. That is the federal statute, and it has not changed in its core intent since 1970. What has changed is how aggressively the EPA enforces it. Now here is where this gets important for anyone in business. The law does not just apply to the person turning wrenches. It applies to the manufacturer of the part, the distributor, the retailer, the online marketplace. If you are anywhere in the chain between a defeat device and a vehicle, you are potentially liable. The penalties are not small either. We are talking up to $45,268 per non-compliant vehicle or engine, $4,527 per tampering event or sale of a defeat device, and $45,268 per day for reporting and record-keeping violations. These are not theoretical numbers. These are the current published penalty amounts. Between fiscal year 2020 and fiscal year 2023, the EPA wrapped up 172 civil enforcement cases, resulting in $55.05 million in civil penalties. On top of that, at least 17 criminal cases produced $5.06 million in additional fines and 54 months of collective prison time. People are going to jail over this. Let's talk about some real names. Punch It Performance and Tuning got hit with an $850,000 civil penalty. The cast of the Diesel Brothers reality TV show and their associated companies also got fined $850,000 in March of 2020 for Clean Air Act violations. Sinister Diesel, a California parts maker, pleaded guilty to criminal charges and paid $1 million. PPEI and its owner, Corey Willis, were ordered to pay $1.55 million in criminal fines, plus another $1.55 million in civil penalties. FlowPro Performance Exhaust and Thunder Diesel were forced to halt sales and pay $1.06 million. These are not Fortune 500 companies. These are small and mid-sized businesses in the automotive aftermarket that thought they were operating in a gray area. They were not. And then there's eBay. In September 2023, the Department of Justice sued eBay, alleging the platform sold, offered for sale, or caused the sale of more than 343,000 defeat devices between November 2015 and January 2023. At $5,580 per device, the estimated potential fines approached $2 billion. eBay won a dismissal in September 2024 by arguing Section 230 of the Communications Decency Act shielded them as a platform. But the Department of Justice appealed that ruling in November 2024, and that case is still alive. If the appeal succeeds, it changes liability for every online marketplace selling automotive parts. So why is all of this ramping up now? Two reasons. First, the scale of the problem is enormous. A 2020 report from the Environmental Protection Agency found that 15% of diesel trucks in the United States have had their emissions controls deleted. That's roughly 550,000 diesel pickups running around with no catalytic converters, no diesel particulate filters, and no selective catalytic reduction systems. The pollution impact is staggering. Those known defeat device sales for diesel trucks produced between 2009 and 2020 resulted in more than 570,000 tons of excess nitrogen oxides and 5,000 tons of excess particulate matter over the lifetime of those trucks. A single tampered diesel truck can increase nitrogen oxides by 310 times, non-methane hydrocarbons by 1,400 times, and carbon monoxide by 120 times compared to a properly equipped vehicle. Drew Kojak, executive director of the International Council on Clean Transportation, told the New York Times, "This is far more alarming and widespread than the Volkswagen scandal. Because these are trucks, the amount of pollution is far, far higher." Remember, the Volkswagen scandal involved about 590,000 vehicles and cost VW $33.3 billion in fines, penalties, settlements, and buyback costs. The aftermarket defeat device problem involves a comparable number of vehicles, but spread across thousands of small sellers and installers. The second reason enforcement is intensifying is the death of the competition use only loophole. For decades, parts manufacturers slapped labels on defeat devices that said for off-road use only or for competition use only, and everyone looked the other way. The EPA's official position now is crystal clear. Those labels no longer provide protection. The agency has found that hundreds of thousands of defeat devices sold under competition only claims ended up on trucks driven daily on public roads. And here is the part that surprises most people. The EPA maintains that even converting a street-legal vehicle into a dedicated race car that never touches public roads may still violate the Clean Air Act. They proposed this interpretation in 2015 under Administrator Gina McCarthy. They withdrew the specific proposed rule in 2016 after massive public backlash, but they never changed their legal position. This is why SEMA and PRI pushed hard for the RPM Act, the Recognizing the Protection of Motorsports Act, a bipartisan bill that would have explicitly legalized emissions modifications on vehicles converted to competition-only use. NASCAR legend Richard Petty and NHRA top fuel driver Antron Brown both testified before Congress in support. Petty said the EPA was overstepping its jurisdiction and penalizing small motorsports parts businesses. The bill was introduced, reintroduced, debated, and ultimately failed to pass the 117th Congress. As of now, the legal gray area for motorsports remains unresolved. Let me bring this to the state level, because it is getting even more restrictive. Colorado passed a law effective January 1, 2024, that makes it illegal to sell or even transfer title to a tampered vehicle. Any vehicle registered for on-road or off-road use in any state must comply with all Colorado and Federal Environmental Protection Agency emissions laws while it is in Colorado. New York now requires all replacement catalytic converters to meet California Air Resources Board standards, not just Federal Environmental Protection Agency standards. More states are adopting CARB requirements every year, which means the compliance burden on parts sellers and repair shops is not just federal anymore. It is a patchwork of increasingly strict state regulations. So what does all of this mean if you're in business? If you manufacture, distribute, sell, or install aftermarket automotive parts, you need to understand three things. 1. The law is broader than you think. It covers hardware and software. Tuners, exhaust systems, EGR delete kits, hollowed-out catalytic converters, and even OBD reprogramming can all constitute violations. 2. Enforcement isn't slowing down. The EPA designated stopping aftermarket defeat devices as a national compliance initiative starting in 2020, and they resolved 38 civil cases in fiscal year 2023 alone. 3. The penalties can destroy your business. An $850,000 fine destroys most small businesses. Criminal charges mean personal liability for owners and operators. As Assistant Attorney General Todd Kim put it, businesses that manufacture and sell illegal devices to defeat a vehicle's emissions controls foster pollution and risk decades of progress in curtailing harmful emissions from motor vehicles in this country. The Clean Air Act isn't new, and it isn't secret. But the enforcement posture we're seeing right now is unlike anything in the previous 50 years. The businesses that survive this era will be the ones that understood the law before the EPA came knocking, not after.